Good evening, everyone. Today we are going to discuss about the law of torts. It's part of the first semester of LLB course of the 3-year LLB course that I am doing. Okay, now let's look at what a tort means. A tort is a wrong which is independent of contract, which gives rise to a civil remedy for which compensation is recoverable. It's an act of omission which prejudicially affects a person in some private legal right. The word tort is derived from the Latin word tortum, which means to twist and implies the conduct which is twisted or tortuous. Now, we see that in India, most of the time, many people don't file for a tort, they don't make a case out of tort. But if you go to the Western world, tort is something which is very common, and people fight when they feel that they have been civilly wronged. A civil injury for which an action for damage does not lie is not a tort. For example, a public nuisance for which an action for damages lies at the insistence of a member of the public. The principal aim of law of torts is compensation of the victims or defendants. Now, the reason why I gave you the definition for this is so that we could visit something more pertinent to what I want to discuss today, which is explain the justification in tort. Now that we have understood the meaning of tort, let's move on. There are certain circumstances under which the defendant is immune from the liability of a tort. He can plead these grounds to be exempted from tort. The plaintiff will not be able to prove him guilty if he proves these grounds appropriately. Now let's look at the defenses which are available in cases where the justification of tort can be done. For example, volunti non fit injuria, which means on consent or on leave. The second one is acts of God. This is quite common when you actually take an insurance policy. It's clearly mentioned that the policy cannot be claimed on acts of God. I mean, that's one of the clauses that they specify. Then inevitable accidents. Parent, quasi-parental and disciplinary authorities, then statutory authorities, necessity, mistake, judicial acts, quasi-judicial acts, acts of state. Along with this, the various other grounds are contributory negligence, remoteness of damage, plaintiff is wrongdoer, and malicious act of a stranger. Now let's understand a little more about this. Volunti non fit injuria or by consent considers the fact that the plaintiff is in full knowledge of the act and hence cannot claim damage. We have to look at the elements of how it leads to the full knowledge. The consent should be free. The consent has been obtained for a legal activity. The mere knowledge of the act is not sufficient. Let's look at free consent in a liberal manner. The two ways in which a consent can be given is express consent. In this case, for example, a surgeon operating upon a person, you give him the full freedom by signing the document which says that the surgeon is operating, and hence if there is some amount of things going wrong, then we don't hold him responsible for it, because he is doing everything to correct the situation for the patient. The second one is the implied consent. In this case, a cricketer or footballer is fully aware of the dangers or the perils of the game which gets involved during the course of his game. Here, the famed Raman Lamba case would be an example for this. Now, let's also look at the case of Hall versus Brooklyn racing club, the auto racing club. The plaintiff was a mere spectator. However, during a collision of cars which was thrown at the spectator, it injured him. The defendant was not liable to pay him, as such accidents were the perils of the game. So it was understood that when you're being a part of a dangerous game like this, even in the position of a spectator, there could be incidents like this which could happen and which could injure you. So now to understand this further, let's also look at it from the case law point of view. When you're looking at the consent, Lakshmi Rajan versus Mallar Hospital. In this case, Mrs. Lakshmi was examined for a lump in one of her breasts. However, the surgeon removed her uterus instead without her permission. Here, the defendant was penalized for not obtaining consent because the operated part was totally different from what was to be done. Now, the legal act, R.V. Donovan, it was observed that no person can authorize another to commit a crime. Now, I want you to go back and check that case law. Third one is mere knowledge is no consent. The case law for this would be Smith versus Baker. Smith was hired to repair one of the cranes which carried rocks. While doing so, he hurled few stones. He was hurled by few stones from another crane. The defendant had to pay damages as mere knowledge was not sufficient grounds here. So, utmost care was to be taken, which was not done. This rule can be found in use again in the Indian case of MC Mehta versus Union of India. This would be in the oleum gas leak, which happened immediately after the Bhopal gas tragedy. Now, I would want to end with just these few grounds. I would definitely want you to go back and look at all the grounds that we discussed and check for the relevant case laws. Like I always maintain, this is a student perspective, not a professor or a lawyer's perspective. This is a student perspective. Thank you very much. I hope you enjoyed the session. Signing off, Bindu Zachariah George.